And this matter comes before the court today on Ms. Anderson's motion to terminate a PPO that I granted in favor of Ms. Hamp. Looks like, I think I granted it in December. However, or no, I granted it in October. However, it wasn't served on Ms. Anderson until December, and she appealed it shortly after it was served on her, and that's why we're having the hearing today. I will start out with petitioner in this case, Ms. Hamp. I'm going to swear you in and ask you a few questions justifying your support for the PPO, and then if I have additional questions for Ms. Anderson, I'll follow up with her, and then I can make my ruling. So, Ms. Hamp, if you would raise your right hand. Will be the truth and nothing but the truth.
Yes, Your Honor.
Very good. And would you state and spell your name for the record, please?
Montana Hamp, Montanahamp.
Thank you, ma'am. And I granted this PPO to you based on unwanted visits to your house by Miss Anderson. Did you inform her before she visited that she was not welcome to be on your property?
There was a few conversations with my roommate, who is the lease owner of the apartment, that she has stated herself that she did not want Cynthia back on the property. I was not present at the time.
Okay, so you believe that your roommate told her not to show up on the property. Did you allow her to be on the property? What was your stance about her being there, regardless of what your roommate wanted?
I never gave permission, regardless of the situation, but I never told her that it was okay to just show up or to be there.
Okay, you didn't invite her, in other words, to come out or be on the property.
No, there was a few instances where her son, Skyler Osuka, that was staying with us, had asked her to come and get him a few times. So that was on his part, not mine.
Okay, and that's not what the basis for your petition was. Were not those times, they were other times. Why don't you describe what those other times looked like?
In the very beginning, when there was a court issue going on with her son and herself, I did give her permission to reach out to me via Facebook, via Messenger. My phone was very private at the time. I took it upon myself to reach out to her because at some point she was reaching out to my roommate to have a conversation with her about certain things regarding her son and about because they had a no contact order in place, Cynthia herself and her son Skyler. um I reached out to her via Facebook. I said that that was the only way that I was going to do that. We eventually would meet up like at his court hearings if he needed any paperwork, and or meet up with her at gas stations and stuff, not even at the home. But before, there was instances where she would show up at my family member's house looking for me. Um, and then when I would not be home, she would show up here at my current living address, my current living residence, without me even knowing, until I would get a call or I would get a text message from my roommate themselves saying that she is here.
And when she was there, was she dropping off stuff for you? Was she wanting to talk to you? What was your understanding of the reason she was there?
The first couple of times I was under the understanding that she wanted to talk about some things regarding Skylar's being put into jail the original first time. And then the couple of other times there was instances where she was dropping off court paperwork to him instead of just mailing it to our address like I had stated before.
Okay. And another question, and I quickly forgot what that was. When you were meeting her at gas stations and the like, was that because you both understood she was no longer welcome at the original address that she went to?
As far as I'm understanding, yes. But as far as I'm also understanding, it was also because of the PPO that was still, or not PPO, but the no contact that was still in place between her and her son while he
Okay.
was here living with me.
All right. Okay. And you also stated in here one of the basis was the showing up at my home unwelcome, unannounced, without permission. And then the uh, second are texts and multiple calls to your personal cell. You said you kept your cell private. Did she get that?
She was called, it was meant for, I didn't quite put it in there as how it should have. That's my fault at that point. She was calling and making calls and voicemails to my roommate at the time before I had reached out via Facebook and told her that this was the only way that we would communicate for the time being.
Okay. So roommate and what happens there is she's saying she's texting or calling your roommate saying I need to talk to you when she's doing that.
Yes, it was either her reaching out to talk to my roommate regarding her son or her reaching out to talk to me regarding her son.
Okay. And when you say I had to change my number because she was not leaving me alone, well, it doesn't sound like you had to do that because she never had your number.
I did have to change my number, but it was for more of a personal reason, just in case if my number did get out and she did find it in some way or somehow. Because I don't even know how she found my aunt's living address at the time.
Okay. And you also have a note in here about her showing up to your family members'
Yes, my aunt's
addresses.
house.
Okay. Is that also your residence is in Belding?
My residence, yes, I was previously living with my aunt in Cedar Springs.
Okay, and that's the aunt that she's shown up at?
Yes.
And what does that look like when she shows up at your aunt's house?
I had only gotten a brief message from my aunt regarding that she had shown up and started asking questions of how to get a hold of me regarding her son being in jail and stuff. Um, and my aunt would reach out to me through Snapchat and or Facebook to let me know that she was there. My aunt just told her, according to what my aunt had told me, was that she had just told her that she would pass on the message and let me deal with what I needed to deal with if I wanted to reach out.
And was that at a time after you had already told Miss Anderson not to contact you?
That was before.
Okay, so she was trying an alternate route, but it might have just been because she didn't have your number, didn't know the Facebook route yet.
Yes, I had originally had her blocked due to issues from meeting her the very first time when I started dating her son. Um, I had gotten, I had talked with her son regarding that type of issue, and he had suggested that I just block her completely. And that's what I had done. So when I had reached out to her via Facebook after all of the encounters of her showing up to the homes and trying to reach out, I had unblocked her from Facebook, and that's when we started going back and forth on Messenger.
Okay. All right. So really the two issues that I could justify a PPO with here would be at least one visit to your residence when you had told her, or not you directly, but your roommate had told her she was unwelcome there, and you understood that to be the case, and then multiple calls, not to your personal cell, but to your roommate's cell phone in that case.
Yes, and then after my roommate had officially told her that she was done with reaching out and contacting and everything, that's when I had reached out. And I initially made the PPO because of the fact that we were going back and forth over Messenger, and there was a lot of very personal things being brought up and or judged about on my part, or not on my part, but on her part to me.
Yeah.
So that's initially why I had the PPO put in place, was because of being on a kind of a virtual but verbal attack basis with Cynthia.
Okay. All right. No, I think I understand the basis for the PPO. Let me get Miss Anderson's response.
Okay.
All right. All right, Miss Anderson, if you would raise your right hand. Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
Yes, sir.
All right. And could you state and spell your full name for the record, please?
Cynthia Anderson, Cynthia, Anderson, Anderson.
All right. Thank you, Miss Anderson. And Miss Anderson, you've heard the two bases on which Miss Hamp would support her PPO. That is that you visited her residence when you had been told not to visit there, and then second, reached out to a roommate's cell phone or with messages in trying to reach Miss Hamp after she had communicated to you that she didn't want contact. What's your response?
So I want to say that on 8/3, I did go to her aunt's house because my son was arrested for his second offense of domestic violence. So I was trying to get in contact with Miss Hamp to arrange something for the minor child of my son who was living with us at the time prior to the domestic violence. I went to the aunt to try and contact Montana, like I said, to try and find out what we could do to facilitate a pickup for my granddaughter. When I spoke with the aunt, she let me know that she would get in contact with Montana and that if she wanted to contact me, she would. That was on 8/3. So then I left and went home, and that was at the Cedar Springs address that I went
Yep.
to. Then on 8/5, my son had an arraignment at the 63rd District Court for the second offense, domestic violence, at which time I, on the record, because the magistrate asked him where he would be staying because there was a no contact order between he and I, and he told the magistrate 508 Bridge Street in Belding, Michigan with his girlfriend. That's how
Okay.
I found out that address. So that's how I found his address, that address. And then I went to that address to try and talk to them because I wanted to arrange a time that we could all meet because my son wanted to get out of jail. The magistrate told me I couldn't post it. So I spoke with Chloe, who then contacted Montana on her phone. And
Chloe's the
Montana,
roommate that lives there as well.
yes, Chloe Rush.
Okay. And
So
did she tell you not to come back to the address at that time?
no, she did not.
Okay.
She told me on August 12th. I think that's when it was. Let me look at my documentation. Hold on. Oh, October 12th was when Miss Rush told me that I was no longer, she no longer wanted me to be on the property. And that was via phone call. And if you can see that Miss Ruby Race also sent in a letter to the courts because she was in the car with me when Miss Rush called me and told me not to be on her property or I would be caught and prosecuted or charged with trespassing. So after October 5th, I did not go back until the 12th. And then Miss Rush called me via my phone, and told me that. And I did not go back after October 12th until my son contacted me on December 14th and told me and asked me via text message, via messenger to pick him up and that I could get a hotel. And if you can see, there's a police report also stating what happened on the 14th of December through Sergeant Hummel,
I don't
the
think I
Belgian
have
police
a
officer.
copy of the police report.
I have it that Miss Hamp was served with that, and that was given to me. That was put in my paperwork, and it came from the courts. So all of my paperwork that
Oh, you know,
I
I
served.
do. I take that back. I actually do have a copy of it here.
Okay,
I just missed it when I was paging through.
yeah.
Okay. All right. So that happens on the 12th. You're not supposed to go there anymore. Do you go there again after the 12th?
Um, I went there again after the 12th because my son wanted me to pick him up, but I went with Sergeant Hummel as a peace officer, and I explained to Sergeant Hummel that Miss Rush had told me that I should not come on their property because I would be charged with trespassing.
And
So
by
he went
then, the
as a peace
protective
officer.
order in the court, the 63rd District Court, was no longer in effect.
Correct. We finished that case October 2022, I think.
Okay.
It was all settled. So the PPO was taken off. Everything was settled on that day. I want to say it was, hold up. I want to
Yeah. So
say
shortly thereafter, you went to the house to pick up your son,
correct,
but you went accompanied by law enforcement.
correct, because I
And
didn't want to get charged with trespassing.
And this was at your son's request.
Yes, sir.
No, but he didn't go with you. He stayed there at the end of the day?
Yes, sir, because I explained to the Sergeant Hummel, I said, my son wants me to come pick him up, but if he changes his mind, I'm just gonna leave and I'm gonna leave things be. And that's what I did. I
Okay.
left because he changed his mind. And while I was there, I talked to him very briefly, but Mrs. Rush was the person holding the whole entire conversation while I was there. And
What kind
she
of
is the one.
conversation was that?
When the sergeant and I went up to the door, Miss Rush answered the door, and she said that I was asked not to be here or I'd be charged with trespassing. Then she stated that there was a PPO against me, and I basically told her and Sergeant Hummel I did not know anything about any PPO. So
Okay.
then I asked Sergeant Hummel to look in his system to see if he found one, which he did, and he told me and told Miss Rush. At that time, Miss Rush had went back into the home to get her phone to show him that there was one, and Miss Hamp came to the door and showed and gave Miss Rush the paperwork showing the PPO. But Sergeant Hummel stated that since I was not served the PPO, he could not enforce it.
Yeah, no, and that
Which
sounds
I
accurate. So you went to the house, you knew that you were not welcome to be there because the leaseholder had told you that
Mhm,
previously. Therefore, you went with law enforcement at the request of your son.
mhm.
That's how you got there. How about the messages? Um, have you tried to communicate directly with Miss Hamp or, by calling up the roommates? I guess it would be Miss Rush or anyone else at the house?
Yes, yes. So my son was diagnosed with major depression, and at the time of the no contact order, he needed his medications for it because I was in charge of his medication disbursements for previous situations that had happened. So in the beginning, his friend Mark Wilson took him one dose of his medications, but then I found out that he did not get it till way late, which is not good. So that's why I contacted Miss Rush and let her know the first time that we needed to find a different way in which we could communicate, she and I or whoever, so that my son could get his medications. And since that was the only reason I communicated with Miss Rush is to find a different alternate route and way that my son could get his medications because his friend Mark was not doing his due diligence to get him his medication in a timely manner.
Okay. Yeah, and are you his guardian? Is that why you have the medication or?
I am not his guardian. When there was a situation back in 2020, the hospital that he was at, um, the hospital that he was at then, and then the hospital that he was like partial in for January of last year, the nurse had called me and told me to keep his medications locked up and that I was to dispense them.
Okay, all right. So kind of an informal, but really, I mean, he, as an adult, in theory, should be maintaining and taking his own medications. Your experience is he just doesn't do that.
Well, no, what happened, sir, is that he attempted suicide. So,
Ah,
because he attempted suicide, they wanted to put every precaution in place so that he did not attempt that again. So, that's why the nurse from the hospital called me and explained to me that I needed to lock them up
I
and
see.
to dispense them accordingly because of that situation. So, that's what I did per the doctor and per the nurse.
Okay. And your attempts then to reach out were to attempt to get some of the medication to your son so that he could continue taking it as prescribed.
Correct. And his attorney, in August on August 14th of last year, also let whoever know Mark, Montana, my son, without me, let let me know too. All of us know that like I would give him like 7 or 14 pills, and then we'd have to meet up again and give him another 7 or 14 pills just to keep it so it's safe. You know, informally I was told to keep his pills and make sure he got them, but yet not give them 100% to him.
I
for
understand.
the situation that happened in the past.
And if he elects to stay with Miss Hamp, you could provide her, I suppose, with the medication, and you would have to trust that she would keep it locked up and also only give him the doses, as you were instructed.
Yes, but now he is back at our home in Caledonia. He's back at our home in Caledonia, and there was another situation that happened. So now he's on a different medication now. And when he was living with Montana and Chloe for 8 months, he did not take any of his medication.
I see. Okay. But I mean, so there's really no reason that you need to go back to
No, no, sir.
Montana's home at this point going
No, sir.
forward.
No, sir. And I have not been back to that home since December 14th when I was told in front of Sergeant Hummel that I would be caught for trespassing and the whole PPO was in place or whatever. Chloe did tell me that I needed to park at the St. Joseph Church, which is across the road on Pleasant and I can't remember that. Anyway, Pleasant and Bel- uh, Belding and Bridge Street. So I'd park over there and I'd message my son to come and meet me there because he still was seeing his minor child. So I'd pick him up to take him up to Howard City where the drop off was. So I'd go there and park there. And then sometimes I'd park around the corner away from the house, never on the property if needed to pick up my son.
Okay.
I
All
never
right.
went back after that October 12th or
And thus,
December
and
14th.
I could take it there's also no reason to electronically communicate or anything of that
No,
nature with Miss Hamp.
no,
Okay. All right.
no, I have not, sir, I have not communicated with Montana electronically since October 18th. I blocked her.
All right. Miss Hamp, response? If any.
Um, Honestly, since Skyler had moved back to his mother's house, we have not had any contact. We have not had any issues. As far as his medication issue, he did take his medications when they were given. Um, I did I allowed him to distribute his meds the way that he needed to with the amount that Cynthia had given him for those time beings. It was Skylar's option and Skylar's decision to do what he did, which was he flushed his own meds down the toilet. I was not home at the time. I was currently with my daughter while I was visiting my aunt. I was informed later that night that he had done that. Um,
And your daughter is not with Tyler. It's a child from a different relationship.
Yes, I had there was a issue there was a one night stand back in 2021. I was
Yeah. No,
dealing
I
with.
just am trying to get the relationships kind of
Yeah, I
tied together here.
currently
Right. So I mean she's not a reason why you're gonna constantly have contact with the son and going forward.
no, but I am currently pregnant with um Skylar's son.
Okay, well, that's going to create potentially
Complications.
some issues down the road. So, right, and certainly, I would encourage, as all of these things illustrate, the importance of getting a custody and parenting time and child support order in place if warranted. Once a child is born, that then formalizes the relationship and the drop-offs and the exchanges and who's with who and takes away a lot of the conflict that can otherwise arise. I know sometimes people view that as extra or unnecessary, but I would encourage you to go through that legal route. When did baby
Me
do?
me and Skylar are still actually currently together.
I
We
see. He's just living away, but you're still a couple.
Yes.
Yes.
Okay, all right. Well, then you may be able to work some things like that. I was thinking there was some sort of separation here. So,
Oh, no,
okay.
no,
Well, and I don't mean to overstep at all. Even with that being the case, I would still encourage you to formalize all of that via court order. So that if questions do arise down the road, someone has it in black and white. How the things are going to work because uh, I see a lot of cases and that becomes a question and that custody order is the controlling document in the matter. So, all right. Well, for purposes of today, it appears that, you know, when I granted this protective order, there were instances of Miss Anderson showing up at the house, you know, allegedly at Tyler's request to pick him up, and then he changes his mind and goes. But she did show up with a law enforcement officer. She did everything right in that instance. I can't find that a violation or an instance of harassment that would support a protective order. She appears to have done it, you know, according to Hoyle. And the other efforts made to reach out to Miss Hamp, though they were through relatives and kind of unconventional routes. They were also because Miss Hamp had indicated a preference not to be contacted directly on her cell phone and hadn't distributed that number, and had at least at one point blocked Facebook. So the messages, again, though unconventional in the way that they were delivered, you know, they were not intended to be harassing. They were intended, it appears anyways, to be informative in that, gee, here's Tyler's medication, or here are papers from Tyler's court situation that I thought you might want to have, or that we might communicate about. Now, you know, I understand, you know, there's another person that's Skyler in this and is not involved in this hearing whatsoever, and you know, probably has a whole different point of view here, but I can't find that those would justify the continuance of a protective order. I'll grant the motion to terminate the protective order effective today. And you know, since there still is the ongoing relationship with Skyler, you're going to have to work that out and somehow work out, you know, what the level of contact with Miss Anderson, you know, is going to be. And really, it should be at, you know, it's hard to say I don't want contact, but then Skyler, who's living with you, says, well, I do want mom to come by. That kind of puts mom in a bind where she's between her son and the legal order saying no contact or don't come to the property. So you know, I would, and you know, the idea of perhaps him coming out to the church or whatever across the street, if that's what the way it's going to work, then that can work out that way. I can tell you it's going to get about 100 times more complicated when the baby's born. So I would encourage, you know, everyone to try to work out some sort of amicable arrangement during that time. But for the time being, I'll terminate this order and allow things to go forward. No protective order in place.
Can I say something, Your Honor? Sorry.
Yeah, go ahead, Miss Anderson.
So I just want to say that Skyler's living with me, not Montana
Yeah,
anymore.
I understand, right?
And
Staying
so,
with you for the time being, but he's gonna have a baby and there's a relationship.
yeah.
And,
So I understand that. And I also want the courts to know that I have no ill will for Montana. So she and I can sit down and have an adult conversation about how this is going to work, because in the end, they need to be together for the sake of the child. That's all I care about. And that's what needs to be important. The baby is important. Having a good relationship is important, because in the end, the child is the only one that suffers. Not me, not Montana, not my son, not anybody else, just the child. And I think we can, as two adults or as three adults, if my son wants to be involved in the conversation, we all need to sit down and compromise and have good communication and look for the best interest going forward of the child. That's all I care about.
all right, thank you, Miss Anderson. Miss Hamp?
I relatively was going to say the same thing. At some point, there was a very private and spoken conversation between me and her son where we understood that the initial part of the PPO was just, it was based more out of what we felt was disrespect, but now have come to an understanding that it was not disrespect. It was more or less just trying to make sure that he was okay, everything was okay. So I am 100% okay with terminating the PPO. If I could have done it sooner, I probably should have. But I do agree with Miss Anderson. I just want the best for her son. I love her son deeply. I think that we can figure something out as respectful adults, as we should have probably in the beginning. And I'm willing to just move forward, like she said, for the betterment of the child, for the children that are involved, for everyone involved in general.
Good. No, and I certainly wish y'all the best of luck going forward. I know, you know, the son, Skyler, has not been involved in this hearing. I do know, at least from what his statement's been told to me, that he has required medication for major depressive disorder. And I will say that it's a chronic illness. It's not one that's, you know, unfortunately gets cured or goes away. It can be managed with medication and counseling, but life events and including having a baby and possibly, you know, living separate from you, Ms. Hamp, for a period of time and things like that, and the normal relationship up and downs that come with any relationship, can worsen the symptoms. So, you know, unfortunately, people with, you know, significant mental illness, you know, their lives often look something like a roller coaster, in that, you know, there are really good times and there are really hard times. And, you know, however, there are no two people in better, you know, places to evaluate that than his mom and the mother of his child. You know, you're both going to know him better than anyone else. And right, if you can kind of view it as, you know, what's best for baby, and that Skyler has these unique chronic medical needs that aren't his fault, you know, the depressions and illness, you know, it's like getting cancer, high blood pressure, whatever. You get, some people get it, some people don't, and you treat it with medication, and you know, there is a medical way to do it. And a lot of times, unfortunately, like you say, I've heard that 100 times about the person that needs the medication flushing it down the toilet and saying, I don't need it, even though probably the two of you would say, yeah, you should probably keep taking that, because believe it or not, it's really helping you. So I think, you know, if you continue on that course, you know, with the best interest of, you know, really Tyler's medical needs, or Skyler's medical needs, and of course the needs of the child when the child arrives, you know, you can get to a good place. And you two both seem like decent, responsible people who are interested in doing that. And the relationship probably got off on a different foot than either of you'd liked, but I certainly wish you the best of luck going forward.
Thank you
Thank
so
you.
much, sir.
Thank you. With that,
You have
we're
a great day.
concluded. You as well.
Bye-bye.
Ms. Cease, this is your motion to terminate the order. I did receive this, and it appears that your argument here is, Judge, this act, you know, the confrontation between the two of us was instigated by Miss Ward coming at you and your dogs, and she also supports her motion with some other allegations, including that you threatened to put a gun to her daughter's head outside her bedroom window. What's your response to that?
I never did such a thing. I don't even own any guns. I have not owned any guns in a long, long time.
Have you ever communicated with Miss Ward's daughter through the window?
Perhaps as I was walking by, but nothing about any guns at all.
Okay. What kind of communication would there be as you're walking by their house?
Mostly I communicated when she was out on her deck.
Okay. And what would you be saying to her?
At one time I told her she should, there wasn't that much communication, but at one time she was sitting out on her deck and it looked like she was in her underwear, and I responded to her and said, I think you need to put some clothes on, because it looked like she was in her bra and her underpants.
You said you responded to her. Did she say something to you first?
No, I guess the response responded to her wasn't
To her
right.
condition, right. All right. And then after that, was there more, you know, what I'm going to refer to as argument or confrontation between the two of you?
No, I would think I was walking my dogs. I just kept going.
Okay. Now, she also alleges the dogs loudly barking outside her house daily. You did say, I did notice in the police report that you have a couple of corgis.
Yes.
Does that happen, that they're barking outside the house?
As I'm walking them, if they should see her cat outside her house, they do bark. Otherwise, as I'm walking them, they typically don't bark. But if they see another animal or another dog or even somebody across the road, yes, they do bark.
In other words, not limited to Miss Ward's cat, they bark at every cat.
What?
They bark at any cat they see, not just Miss Ward's.
Absolutely.
Yeah, because they're dogs. Okay.
And
All
other
right.
dogs
And
as well.
do you have to walk in front of Miss Ward's house when you're walking your dogs, or is there a sidewalk available on the other side
That's
of
the only
the
way to get out the mobile home park, unless I go way up to the east end of the mobile home park, past about 12 more mobile homes where there will be more dogs, which there will be lots of barking adventures between the other dogs and my dogs.
and said corgis? I understand. And Is it one of the, are there any sidewalks in the mobile home park, or is it,
It's a
you're all there?
sidewalk right next to her house, only I walk on the other side where there's not a sidewalk so that I don't have to be so close to her home.
All right, so your testimony today is you're getting as far away as you can.
That's correct.
Okay, anything else you'd like to add, Ms. Cease?
No, unless she's wanting to have this, I'm wanting to have the PPO dropped, but how about when she sprayed me with bear spray, my dogs, she sprayed with bear spray, it's not on this.
Well, you did put that in your objection, though. I don't think it was necessarily the one I saw in the police
Okay.
report.
Well, I did call the police. And my throat issue is from the bear spray, and I'm going to a ear, nose, throat specialist next week because I still am not able to talk properly without whatever is in my throat caused from the bear spray. She didn't spray me directly. When I bent down as she was spraying my dogs, I inhaled the bear spray as she was spraying my dogs, and they were laying on the ground and I thought they were dead.
Okay, and in trying to help them, revive them, you also breathed in bear spray.
Absolutely right.
And you have filed a police report on the matter?
Well, it was all in the one, yeah, on the one police report of the bear spray, yes.
Oh, okay.
I don't think at that time that I had known that I still have this ongoing situation with my throat and my windpipe, but I'm going to a specialist next week.
Well, I certainly would encourage you to follow up with the police, and, if you think there is a civil action for the injury to you, that would be a matter to take up, with a civil attorney of your choice. Certainly if you think you were assaulted and sustained damages, that would be potentially be a civil action. And I'd leave that to you to consult with an attorney. It also, if your contention there is you were assaulted, well, it could be one incident that might support a PPO in favor of you, though you'd have to illustrate other incidents of threats or harassment as well from Ms. Ward. That's not what we're here from today. Today, I'm just trying to determine whether or not Ms. Ward's PPO can stay in place. So I think I've got everything I need from you. I need to hear from Ms. Ward. And Ms. Ward, if you would please raise your right hand. Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
I do.
Very good. Ms. Ward, what is your response to this, Ms. Reese's statement today that you were the one that kind of launched the attack on the dogs with the pepper spray and kind of spurred this confrontation?
Yes, Your Honor. This has been going on since April. All of the things listed as stalking have occurred. And my daughter has audio of her saying, "gun to your head."
What?
Also, she has commanded the dogs to bark by saying, "woo, woo, woo." And she also knows how to make them stop, but she chose not to. Daily, at the height of it around August, it was five times in one day. Also, very early in the morning, sometimes at 6:15 or 7:15.
Well, she's walking her dogs down the street past your residence.
Yes, Your Honor.
And you think she is inciting them to bark. She said, no, they bark when they see, well, and, they're dogs. They probably do bark when they see squirrels, cats, chipmunks, birds, everything that excites a dog. Some dogs bark a lot, and sounds like these are that type of dog. So that happens. She's on the other side of the street, but the dogs still, you hear them from inside your home. Is that right? You can hear them from inside even when you're not out on the porch, Ms. Ward?
Single pane windows in my home.
Yeah, and it sounds like this is a mobile home park and that everything's pretty close to each other. Is that correct?
Yes.
Yeah. Yeah, no, and that's just the norm in those settings, unfortunately. Okay, well, and I guess you know, the key thing here then is this you know, what's alleged as assault incidents. Are you the one after the dogs were barking, did you go over and you know, I don't want to get too far into the bear spray because it sounds like that might be the subject later of a criminal or a civil case. But were you the one that kind of decided to take action on that day?
I did, and since that occurred, I have some mental health issues, and I have seen a mental health professional.
Okay.
Miss
It
Feast was
sound-
aware of mental health issues a long time ago. She knows that I suffer from depression and severe anxiety, and she's been exacerbating that.
And when you say exacerbating that, I get the walking the dogs is irritating, and you know, I can see, you know, my neighbor's dogs bark occasionally in the middle of the night too, and I have to say it irritates me. However, you know, other than that, are there things that she's intentionally doing that are targeting you?
Yes, Your Honor. I
What would
tried to
those
go
be?
for a way, and she rolled up in her car behind me and pulled into her driveway, and then she ran in the house and looked down, came back out and ran out and looked down the street. I was still on the sidewalk and hopped in her car real quick and followed me again.
We say she followed you, you mean she knows the car right up to you, or she kind of drove the same direction you were walking?
Yes, and my daughter is concerned for my safety, and she has it on video.
And when you say concern for your safety, I mean, is she doing something in the car that's threatening? I mean, she's, you know, riding on the tail of your bumper, something along those lines?
Well, I'm a walker. I do not own my own vehicle.
Okay.
And yet, my daughter was concerned that she was swerving toward the sidewalk as I was walking down the street. So we called 911 and the Lowell police came over.
And they documented it with a police report?
Yes, sir.
Okay. All right. Now that wasn't, I don't think, one of the issues.
It's part of following of a stalking law.
Okay. Yeah, I guess you're saying harassing you and your family for 8 months. Now you also say insults, whistling. The whistling is directed to the dogs to incite them to bark? Or
No,
is
it's
it something
directed
different?
at annoyance. It's directed at us for annoyance. And she never did it before we had a falling out.
And when you say whistling, are these like cat calls or loud whistles with two fingers in my mouth? What kind of whistles are we talking about?
Very loud whistling from her mouth.
Songs, music?
Songs, music.
Not really anything specific, just whistling.
All right. And how about the insults you're listing in here? What she did testify that one time she did say get some clothes on. Anything else?
No, my daughter was not sitting outside with no clothes on. She wears tank tops and sports bras, and that is totally acceptable in public.
Okay. Yeah, I thought she said she directed that to you one time, but you think it was your daughter.
What's the dog?
She started attacking more when my daughter moved in. She came over and she said, "What are you doing to lose weight?" And then she mailed me a card that was insinuating that I was an enabler to my daughter. She's got a genetic bone disease and had surgery coming up.
And she mailed the card to you or to your daughter?
That was the first thing that happened is she mailed a card to me with no return address. So I opened it thinking it might be from a family member. And it was very, very derogatory.
You mean it was a written card or it, what was it? What would the card say?
It was handwritten. I have the card. It said something to the effect of, "I don't know what I did to deserve this," because we told her to go away and not come back because we didn't enjoy her company.
I see. You told this to Miss Cece and she was then sending it back to you kind of, you know, right, inquiring about what happened, or, yeah.
Yes, and she became a nuisance. She was coming over sometimes 3 times a day, and every time I got company.
When you say coming over, you mean coming and knocking on your door or walking past with the dogs?
Yes, she was coming over to my house when I had company and stuff and intruding.
Knocking on the door and wanting to visit. And that was pre the falling out that you just testified about.
Yes, we tried to high road for about 4 months.
Okay, all right. Well, today, you know, the matter before the court is the protective order that you filed. It is based partially upon you know, what you described in here as looks like threats towards your daughter. She has testified she didn't make any threats, though there may have been, you know, back and forth with the daughter to through the daughter's bedroom window because there has been some interaction between you and your family there. You're stating that those are insults or intentional whistling, and of course the dogs barking outside the house, provoking. However, you know, when I consider the situation as a whole and heard the testimony today, you know, I find, at least with regard to walking the dogs on the street, she did testify she walks on the other side so as to be as far away. I guess she, in theory, probably could walk down the sidewalk and those dogs would be even closer to your home and louder. She testifies she walks on the other side of the street, but that the dogs do bark, you know, and as I said, dogs do bark, but really my view of, you know, barking and nuisance pets is it's really more an issue for either animal control or perhaps the mobile home parks rule. You know, if there is a rule about the number of animals or you know, how they're to behave or to be on leash, but I'm not seeing anything like that that would create what I would, you know, calculate as a threat or harassment. And it appears that, you know, in an effort, there was a confrontation at some point in an effort to stop that where you, but you were the one that initiated that. The verbal threats and the threats with the vehicle, they appear to be directed both at you. And you did say that they happened more so when your daughter, after your daughter moved in, it appears the falling out, you know, kind of coincided with that. However, you know, the nature of a personal protective order is, of course, it's personal. That means, you know, that insofar that threats, insults, or whatever are directed at your daughter, unless she's saying to your daughter, you know, and by the way, go tell your mom such and so, in an effort to convey a threat or an insult or harassment towards you, even though you may take it personally, as most of us would if it was directed towards one of our children, it's not directed at you. It would be a matter perhaps for a personal protective order favoring your daughter, but not for you, Miss Ward. So at this time, I will find that there's insufficient evidence to justify the continuance of the personal protective order. I will terminate it at this time. Certainly, you two are going to live near each other. It appears that this matter has already, you know, escalated on at least one occasion. To the point where Miss Cece testified today that, you know, she has some ongoing physical consequences. And, you know, you also testified, Miss Ward, that, you know, it's challenging to your mental health to have, you know, and anxiety, as it would be to anyone, of having this go on all the time, this confrontation. But you know what, the one thing that I can't do with a protective order is I obviously can't order you to be friends again, nor can I order that one or the other of you move out of that community and live somewhere else. You're going to have to figure out a way forward. That may mean changing, you know, at sometimes the directions for Miss Cece of where you walk, and just in being considerate if it's early in the morning or something, trying to find the kind of least damaging route that you can walk with those dogs. Although I know some dogs, and the trailer park undoubtedly has rules that says you're supposed to observe quiet hours between such and so. And I would expect everyone to observe those and do those things, but I don't think this is a case for a protective order, as the facts are before me today. So I'll terminate the protective order and sign an order terminating it. Does remain in effect until that order gets in the system and the protective order gets removed from lien. So you should continue to observe it, Ms. Cece, as if it's in effect until that happens, but you will get a copy of that and all the documents terminating it, and then it'll be terminated going forward. However, you're both neighbors still. You're going to live in close proximity to each other, and my hope is that like I say, in no way I can order you to restore a friendship or a friendly communication with each other. However, my expectation and is that you'll at least obey the law and give each other enough space with respect to each other's respective needs. That's just kind of trying to be just like when my dog starts barking, especially at nighttime. I hate to have that happening, and I try to get outside as quick as I can and get that dog inside so she doesn't wake up my neighbors, and I trust my neighbors are doing the same for me. I would expect that you take the best steps you can to, be respectful of the other person. So, with that, I will sign an order and get it out in the mail, and the hearing is concluded. Thank you both.
Thank you.
We are here in the case of Kimona Jones versus Lakeisha Kearney.
And this matter comes before the court today on the respondent, Ms. Kearney's motion to terminate a personal protective order that I granted in favor of Ms. Jones back, it looks like, on or about January of this year. So I do have both parties present today, and the way I think I'm going to proceed is I do have the objection here. I'll take some testimony from Ms. Jones because it's her burden to support the protective order with the two incidents of harassing or threatening conduct, and if necessary, any responsive testimony from Ms. Kearney. And then I can make my ruling on whether or not the protective order will remain in place after today. I do note that there is a alleged violation, and we've already set a separate hearing on that violation. I'm going to keep that separate for the time being, though I can certainly arraign that at the conclusion of today's hearing and advise Ms. Kearney of her rights with regard to the next hearing, and maybe we can just simply set that. Have I already done the order to show cause on that one, Lisa?
No, it is scheduled for a show cause.
That's going to be a show cause. Actually, I can't take
Yeah.
care of that today because that's pretty short. But let me take care of the termination. We'll take them in order. Ms. Kearney, I'll swear you in first and I'm going to take Ms. Jones' testimony first, and she's the petitioner. Ms. Jones, if you'd raise your right hand. Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
Yes.
All right. And would you state and spell your full name for the record, please?
Kimona Jones, K-E, M as in Mary, O, N as in Nancy, A. Jones, J-O-N as in Nancy, E-S.
All right, thank you, Ms. Jones. And Ms. Jones, I went back to the original petition for the protective order, and of course, you're required to identify two instances of threatening or harassing conduct in order to sustain this. The first one you testified to was a confrontation that started when you were on the way to church, and Ms. Kearney followed you. And then a confrontation ensued. Why don't you tell me what happened in that case?
We had an altercation, a verbal altercation outside her home. And when I left her home, she followed me to church. And I rode past our church to kind of avoid the conflict being with the members walking inside. And it turned physical, and there was a lot of words exchange. There were people who were on their way to church, and they came and kind of diffused the situation. I went over one of the members' homes afterwards, and she followed me over there, yelling for me to come outside. She was sending threatening text messages to my phone.
Okay. Now you said that all started outside of her home?
Correct. We were meeting at her house. She asked me to return her. We were friends. We had a tenure of a friendship, and we just had an argument that escalated where I called her out her name, and she called me out my name, and I took off. When I took off, she jumped in her car to follow me.
She followed, and the confrontation occurs. It looks like you stated you got out of your car after you stopped on Garden Street and got out asking her to stop following you. Your statement in here, she swung at you and that forced you to defend yourself, i.e. fighting back. Is
Correct.
that still your statement as to what happened with the confrontation?
Yes, sir.
Okay, and then after that confrontation, you said there was still some following, and an hour after, including her following you to perhaps another church member's home, and yelling at you to come outside. You said in the petition for round two, I take that for you took that to be additional fighting.
Correct. That's what she was requesting.
Okay. All right. And, for purposes of a PPO, it's the law is not as obvious as it probably could be. It considers everything that kind of happens in one back-to-back incident, even though there were several different locations that it happens. It's all one incident. So I'm going to count that all as one incident. You also stated in the petition that there were text messages threatening to beat you up on December 10th. How do you know those text messages came from Miss Kearney?
Well, as I stated, we had a friendship, so her phone number is in my phone. She's in my
Okay,
contacts.
it showed up as her.
Correct.
And can you, do you still have copies of the messages?
I do. I tried to figure out how to upload them on that court. That whole system is kind of
Yeah,
new.
our whole evidence
Yes,
document
yes.
thing. No, you're not the first one to struggle with that, I can tell
Okay.
you.
I definitely have the text messages
All right, why
from
don't you
her.
state to me what she said to you by text on December 10th?
All right, I'm gonna go to them now. December 10th it's very lengthy.
All right, read me the highlights if you can, the threatening part.
I left your miserable saggy pants tail alone to keep from seriously hurting you. But I see you want these problems, so you gotta see me for round two. And this time nobody gonna be there to save you. Lying, telling people you with me. I missed when I swung. You don't know those people out there that saw you. I have a recording of me telling you to get out your car several times, and you didn't get out till you knew people would get me off you. I hit you in your mouth like you're gonna get again since you can't keep your name out my mouth.
All right. Well, I think that suffices, certainly as what I would characterize as a threatening text. And that came directly from Miss Kearney to you as your testimony.
Correct.
All right. Well, let me get Miss Kearney's response. Miss Kearney, if you would raise your right hand. Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
I do.
Very good. Miss Kearney, what's your response on these two incidents? In your request to terminate, you say that you're not a threat. I would say, when you're asking for round two, to me, that seems like there's at least a threat of a fight. Can't say who's going to win the fight, but to me, it sounds like a threat of a physical fight. Do I have it wrong?
You're not wrong, but we did have, as she stated, I texted her and asked her if I could have my house keys. I didn't want anything to do with her anymore. She came to me, I asked her if we could meet so I could get my house keys. She came to meet with me so I can get my house keys. That's how it escalated. She was upset because I didn't want her to be around me or my children anymore because of a lot of things that she was doing. So I was revoking her access to me. She wouldn't give me my house keys. She made a scene in front of my house. My neighbors were coming outside. As far as her saying I followed her, Your Honor, we attend the same church. That's something that she didn't tell you. I did not follow her. We had Bible study that night. Although I was not going to Bible study that night, I was dropping my children off at Bible study.
Got it. And you happen to be at least in the same proximity, it looks like, in the vehicles. Was there a point where the two of you get out of the vehicles and there's a physical fight?
Yes, it was.
Okay.
She got out of her vehicle. She was very upset again because I wanted my house keys and wanted nothing else to do with it. We did have a good friendship at first, but again, there were a lot of things that she was doing that I didn't want to be a part of anymore. So because I asked for my house keys, she was upset, calling me out my name. It did result into a physical altercation. As far as her saying I followed her to a church member's house, she texted me. I still have that text message. She texted me and said, "You know my location. What's up?"
Okay. So, I mean, what I'm hearing on this is that you're saying, well, she instigated some of these contacts, and even if I responded saying you want round two, or, that nonetheless, she was the one that kind of started the back and forth at least.
She instigated a lot of it and still going on with the same things.
Okay. All right. Well, I mean, for today's purposes, in terms of your motion to terminate, I can find that there were two incidents. There was a physical fight, and I recognize every physical fight has two participants, and I'm not going to assess blame for it, but I am going to say, after a physical fight, both people probably feel like, boy, that could get physical again if we run into each other. And that you followed up with text messages, as you acknowledged today, later on in December. It may have been instigated by her, or messages or communications out there, but nonetheless, there was another message where you said, hey, you and I need to get together and we'll have round two. She perceived that as threatening because of what went down before. And I think that was reasonable. I think any reasonable person would say, okay, there's a threat if, Miss Kearney and I get nose to nose together again, it's going to come to hands are going to be thrown, as my kids would say, and that's what these protective orders are intended to do. They can't make you rekindle a friendship or anything of that nature. Don't fool myself that the court has any say in that. However, I sometimes liken it to a boxing match, where the referee gets between the two fighters and says, hey, this round's over. The two of you are going to go back to your corners. You're not going to punch each other for X, Y, and Z of time, until, and of course, our goal isn't that the fight resumes after the bell rings again or something like that. The goal in the community is that, you're not taking matters into your own hands. You're going down the legal route, which is this route that we're on right now, that route of a protective order. So I'm going to leave the protective order in place. I'm not going to hear the testimony about the alleged violation at this time. However, I can advise you of your rights, Ms. Kearney, regarding the hearing, regarding that, and allow you to plead guilty or not guilty at this time. And I do need to warn you ahead of time, Ms. Kearney, and I know I've already, did I swear you in at the start of this, Ms. Kearney?
You did.
I had you take an oath. Yeah. Then you need to know that if I did find that you violated the protective order and I found you in contempt of court, I could send you to the Kent County Jail for up to 93 days and or a $400 fine. You understand that?
Yes.
Okay. And you also understand if you deny that you violated the protective order here, and I'm looking at an incident that involves the candied yam on Division Street, that you're entitled to a hearing. And during that hearing, you're also entitled to be represented by an attorney. And further, I'll appoint an attorney to represent you. If you would like to be represented by an attorney, but you can't afford to hire an attorney of your own choice, that attorney can cross-examine Ms. Jones on her claims that you violated the protective order, and also cross-examine any witnesses that Ms. Jones might call to support her case, as well as use subpoena power to bring in witnesses or evidence that would support your side of the story. So you understand that you have that right to a hearing?
Yes.
All right. And would you like to enter a plea of guilty or not guilty at this time?
Not guilty.
Very well. I will enter a not guilty plea. I will set this matter then for an evidentiary hearing in the future. During that hearing, The petitioner, Ms. Jones, will be represented by the Kent County Prosecutor's Office. I will send you the information to request an appointed attorney if you'd like to do that, Ms. Kearney, or of course, if you choose and have the money to do so, you may hire an attorney of your choice to represent you at the hearing. Lisa, do we have a date and time for the hearing?
We do April 24 at 3 o'clock on Zoom.
That hearing to be conducted April 24th at 3 p.m. and I will conduct that via Zoom. Although either of you, particularly after consulting with an attorney, may, if you decided for whatever reason you wanted to be in person in the courtroom, you would be entitled to do that. I prefer to do this via Zoom because in particular, in the case of a protective order where you're not supposed to be within a certain, you're not supposed to be able to see each other, well, it ensures that we don't violate that in the courthouse before the hearing. However, I'll conduct this matter via Zoom at that time and date, unless either of the parties object to a hearing via Zoom. In the meantime, the protective order does remain in place. I did note the comment in the response that the two of you go to church together. And I don't ever want to make a protective order something that prevents a person from going to church or going to their job or going to school. My advice to you, Ms. Kearney, as you are the respondent, is you are welcome to go to the same church. However, you should make whatever efforts you can to put a distance between yourself and Miss Jones. That is not intentionally go in her direction. Now, if she intentionally comes in your direction, she then, if she claims a violation, but she indeed is the one instigating it, she'll have a hard time proving that you violated it. The main thing I like to see is that the respondent, which is you in this case, Ms. Kearney, tried your best to avoid anything that could turn into a physical fight. I know that's not always easy, and people get together, and it sounds like there are groups, and it's a, very active church, which is a great thing. I would like, you to both get the benefit of that still, but Ms. Kearney, you're going to have to take the initiative while this order is in place to put some distance between yourself and Ms. Jones. I do note that the order, I think, was granted until July. It'll expire in July of this year. That's the other thing about protective orders is they're civil matters. It's not as if you have a criminal record coming out of this, Ms. Kearney. A note of the protective order is in the law enforcement information network. So if the police were to be called, they would find that you're the respondent and they would take you into custody. However, if they found that you did some action that could be construed as a violation of the protective order, i.e. that you went to Ms. Jones' house, for example, I trust that you're not going to do that. It's only going to remain in effect till July, at which point Ms. Jones can apply for renewal if she thinks that it's being intentionally violated during the period, and then it could be extended. It also could run out. These aren't super long lasting things. As legal items go, I know July seems a long way off sitting here with snow on the ground still, but it'll be here before we know it. And of course, the hope is that, you're both adults, you're both on top of it, church going, adults, who sound to me like, you can, represent yourself very capably, in a setting like this where you're speaking on your own behalf, that, you'll say, hey, I wish the situation was different. It's not exactly like I'd like it, but here's how we get on with life without at least coming to a fight. Because that's what we're trying to avoid here is kind of the self-help where people go out in the street and throw hands, and then we get criminal charges and even more law enforcement involvement, and that can have longer lasting repercussions. If you pick up an assault charge or whatever, that can follow you down the road. Whereas a protective order, once they go away for good. I take them out of the law enforcement information network. It's like it never existed. So it's kind of a chance to go back to those corners, take a breather, say, hey, I've got other things in my life. This friendship once was important to me, but, there was a falling out and I have to set that aside and just, get on with my own life best I can. And, I think you're both, sounds like very capable of doing that without coming in front of me. So I'll conduct the hearing at the hearing's scheduled date. And I wish the both of you a safe weekend. Thank you.
Thank you.
We are here in the case of Shelby Peavy versus Christopher Bryant.
All right, and this matter comes before the court on an order to show cause requested by the petitioner, Ms. Peavy, as to why Mr. Bryant shouldn't be held in contempt of court for violating the court's order protecting Ms. Peavy specifically by a video sent, I believe, to Ms. Peavy's mother in this case. So as an initial matter, Mr. Bryant, I need to advise you of your rights. If you would please raise your right hand. Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
I do.
Very good. Mr. Bryant, you understand that if I found you in violation of my protective order, I could find you in contempt of court, and that carries a potential penalty of up to 93 days in the Kent County Jail and or a $400 fine?
Yes, Your Honor.
Okay. And you also understand that if you disagree that you violated the protective order, that you're entitled to an evidentiary hearing. I would enter a not guilty plea on your behalf today, if that's what you'd like to do. And during that hearing, you would be entitled to be represented by an attorney because of that potential jail penalty. If you can't afford an attorney, I would appoint one for you at no cost to you. That attorney could cross-examine Ms. Peavy regarding the alleged violations and could also cross-examine any other witnesses that the prosecutor would put on the stand, because the prosecutor represents the petitioner during the hearing. Your lawyer could also use the subpoena power to bring in any witnesses or evidence that would support your side of the story. And then following that hearing, I'd make a determination as to whether or not the order had been violated and whether or not you were in contempt of court. So you understand that right to a hearing, Mr. Bryant?
Yes, Your Honor.
All right. And given all that, have you had an opportunity to review this alleged violation involves you sending a video and a bunch of photos and videos of Miss Peavy to her mother?
Yes, Your Honor. I've had time to review them.
All right. And is your desire at this time to enter a plea of guilty or not guilty?
Not guilty, Your Honor.
Very well. I will enter a not guilty plea. I'll set this matter for a hearing. As I said, the hearing will, and I'll also send you the documents, Mr. Bryant, that you will need to fill out if you need to request a court-appointed hearing. Of course, if a court-appointed attorney for that hearing, if you wish to and you have the money to do so, you may hire an attorney of your choice. That would be up to you. I'll send you the documents either way so that you have both options. Lisa, do we have a time and date for the hearing?
Yes, April 24 at 2:30.
Hearing to be April the 24th at 2:30 p.m.
On Zoom.
And that will be via Zoom. I do these via Zoom so that it's more convenient, I feel like, for the parties, and also it avoids the situation of the both of you coming together to be in the courthouse for the hearing and potentially inadvertently having contact with each other in violating the order in that way. However, if you decide on your own or after consulting with an attorney you want it to be in person, just have that attorney notify the court via Lisa and or via the PPO office, and I'll set the hearing in person. But otherwise, it'll be on Zoom, just as we proceeded today. Anything else to place on the record this time, Ms. Peavy?
Oh, with him sending the video, that is a violation of the PPO.
Well, the key to prove that is that it has to be, if that was sent to your mom and it was, gee, like, he was following up on a relationship with your mom and never intended her to share that with you. Now, and you may say, I know my own relationship with my mother, that's a little hard to believe, but that's the case he would have to prove, is that his intent in sending that was to communicate it to your mom, not to have her share it with you in the hopes that, it was kind of a backdoor way of getting your attention. So that's my answer. That's kind of what the proofs will be about at the hearing.
Okay.
Thank you. Anything else, Mr. Bryant?
Just in case, because I've had an issue in the past with not just courts, but with debt collectors and mail coming to me. If there is an issue with the app or any issue that I have trying to contact the courts in regards to this matter, how is there a way that I can go about contacting somebody?
Yeah, you can call my chambers, which is 616
Okay.
632-5020.
632-5020. Okay,
Yep,
thank you.
and, Lisa's my judicial clerk who handles
Actually-
protective orders. Go ahead, Lisa.
5018 is my number.
5018. Okay, thank you, Your Honor.
Thank you, and thank you for the correction, Lisa. I guess that 5020 is probably the number I'm supposed to answer that I never probably do. So I'd like to say, because I'm on the bench all day, that's the reason I'm going to go with. So, all right. Thank you all for attending, and the order does remain in place. So I'm going to expect, of course, that it is obeyed until such time as it expires. So with that, I wish you both a safe weekend, and we are concluded.
Thank you, Your Honor.
Thank you.